Hello, everyone, and welcome to the latest installment of Kelleher and Holland's Employment Law Lunch and Learns. Today, we're going to snack on one of the most consequential workforce issues facing businesses of all sizes, the proper classification of workers as employees or independent contractors. This is an area where the legal landscape is shifting rapidly and where the cost of getting it wrong could be substantial. Here's what we'll cover in the next 30 minutes. The major federal classification tests, IRS, Department of Labor, and common law, Illinois specific rules, the real world consequences of misclassification, and practical best practices for contracts and operational safeguards. We encourage you to ask any questions using the Q&A button in the Zoom control panel. And depending on time, we'll try to answer them live or we'll follow up with you afterwards. Our tried and true panel is back again for today's presentation, Andy Bowling and Madeline Kelleher. Thanks to you both for being here today and putting this information together. So let's get started. Andy, I know you were eager to discuss this topic with our audience today, so please tell us why this is an important discussion.
Thank you, Amy, and hello, everyone. Thank you for attending our program. Well, loyal diners who may have attended a program a couple years ago would have heard us talking about changes to the independent contractor rules that were launched by the former political administration. I'll call it the Biden administration test, which completely reversed employer-friendly rules that had been passed during the first Trump administration. And we talked then about how the issue of independent contractor classification, the rule is essentially a tennis ball, and it's lobbed and volleyed across the net, and it can change depending on which party holds the racket and is hitting the ball. And to really no one's surprise, the current administration has issued a proposed change to the federal guidance of how do you determine if someone is an independent contractor. And this guidance, if enacted, and there is still comment that is being accepted until the end of this month, will essentially restore the rules that were in place until 2024, when the Biden administration changed the existing landscape. The Biden rule, and this is the rule that is still in place, it uses a 6-factor economic reality test to determine if someone is an independent contractor under the federal wage and hour law, the Fair Labor Standards Act. And what it did was it significantly raised the bar for showing independent contractor status. In fact, in its guidance that surrounds the proposed new rule, the current Department of Labor says that the old rule and current rule was unworkably vague, led to unpredictable outcomes, and could be viewed as setting a higher bar to find independent contractor status than the law requires. And it also, in my opinion, correctly states that the 2024 rule had a chilling effect on the use of independent contractor arrangements, did not adhere to existing U.S. Supreme Court case law, and was fundamentally incompatible with the modern gig economy. According to this Department of Labor in their 2026 guidance, the Biden rule intentionally created legal ambiguity in the goal of discouraging the use of contractor structures. And this goes back to a fundamental policy difference between traditionally the Democratic Party, which frowns on non-employee relationships. They want to expand the universe of workers who enjoy employee protections and who can be organized into labor unions, etc. Republican Party, in contrast, is generally more in favor of an arm's length, some might say laissez-faire construction that assumes that parties enjoy the fundamental judgment, discretion, and knowledge to classify the structure of their engagement. Now, the current test, the Biden test from 2024, was limited to federal wage and hour cases. If enacted, the 2026 new Trump rule would be broader in application and will cover other important federal laws, including the Family and Medical Leave Act. But what you're going to hear throughout our presentation today from Madeline and from me is that regardless of whether you are dealing with a particular federal agency or focus exclusively on federal law, there are still going to be significant landmines and areas of risk that will withstand any change to the federal law. And it's also very important, and Madeline and I often remind our clients of this, that the 2024 Biden rule is still the law of the land until formally rescinded. And continues to be cited by courts in lawsuits that involve federal wage and hour issues. And so, there's a key risk factor that people need to consider. If you are in a traditionally pro-employee blue state, such as Illinois, California, Massachusetts, New York, New Jersey, there are likely state law rules that are much more onerous than the federal rule, even the 2024 Biden rule. And so we're going to talk in more detail about some of the nuances of the proposed changes at the federal level, but we also want to remind our certainly blue state audiences and companies who might be in red states but have contractors in blue states that the federal law is just a floor, and states are free to put a second story and a third story on top of the first floor. And the highest story, the highest level, the most protective state law is the law that you must conform with. And we're also going to talk about the reality, and this is something I appreciate in the proposed changes, that the old rules and even the Biden rule still in effect glosses over the transforming gig economy that is so dominant across many industrial sectors of our country. And we continue to see, and businesses are still encountered on a regular basis with claims by individuals who are alleging misclassification. And this is a trend not only in the United States, but throughout the world. Who is a worker, who is an employee, and who is a contractor? In Europe, in some countries, there are 3 categories of workers. That's very much a political hot potato and the source of lots of work in the courts. Now, Madeline is going to talk about the different tests that the federal government can use to classify workers.
All right, Madeline, let's get into it. Tell us about the tests that the government uses to classify these workers.
Sure, absolutely. So the federal government uses 2 tests to determine whether a worker is an employee or an independent contractor, and this depends on the enforcing authority, whether it be the IRS or the United States Department of Labor, or DOL. So let's start with the IRS. For federal tax purposes, the IRS uses what it's often called the common law test, which evolves from an older 20-factor test. Today, the IRS organizes its analysis into 3 categories. 1, behavioral control. So what is behavioral control? It asks, does the business have the right to direct and control how the worker does the work? This includes whether the business provides training, sets specific hours, dictates methods, or requires detailed reports. The second would be financial control. Does the business control the economic aspects of the arrangement? Key factors would include whether the worker has unreimbursed business expenses, has a significant investment in their own tools or facilities, can realize their own profit or loss, makes their services available to the open market, and how they are paid, flat fee versus hourly wages. The last common test, number 3, would be the relationship of the parties. So what is the nature of the relationship? Are there written contracts? Does the worker receive employee type benefits like insurance or retirement plans? Is the relationship project based or indefinite? Is the work a key aspect of the regular business? And that's a big one. The critical point here is that the IRS looks at the actual working relationship, not just the written contract. You can have a beautifully drafted independent contractor agreement, but if the day-to-day reality looks like an employment relationship, the IRS will treat it as one. So moving on to the Department of Labor. So for purposes of the Fair Labor Standards Act, which governs minimum wage and overtime, the U.S. Department of Labor applies a different test known as the economic reality test. This central question in the economic reality test is, as a matter of economic reality, is the worker economically dependent on the hiring entity or truly in business for themselves? The Biden administration's 2024 final rule articulated 6 factors, with no single factor being determinative. The court looks at all factors and kind of does a weight process. 6 factors are: 1, the worker's opportunity for profit or loss, depending on managerial skill. 2, investments by the worker and the hiring entity. 3, the degree of permanence of the work relationship. 4, the nature and degree and control exercised by the hiring entity. 5, the extent to which the work is an integral part of the hiring entity's business. And 6, the worker's skill and initiative. Now, as Andy was mentioning earlier, here's where it gets complicated. The current Department of Labor is no longer enforcing the 2024 rule and has proposed a 2026 replacement. The proposed 2026 replacement rule is going to elevate the 2 core factors, the nature and degree of control and the worker's opportunity for profit or loss, as carrying the most weight. The remaining factors would also be considered, but as secondary. But remember, the 2024 rule, as Andy was saying, remains available in courts to private litigants. A worker who files a Fair Labor Standards Act lawsuit does not need the Department of Labor to bring the case for them. Their attorney will use whichever framework is most favorable, and right now that means the 2024 6-factor test. So it's very much alive in courtrooms, even if dormant at the agency level. So, like Andy was mentioning earlier, businesses really do have to be aware of both frameworks.
So, Andy, what additional rules apply in Illinois?
Well, in Illinois, much like other blue states, and California in particular, there's one fundamental form of test called the ABC test that applies to Illinois-based wage and hour claims under the State Wage Payment Act. And it's also used for purposes of determining whether someone is eligible for unemployment compensation. And this is a very, very high bar to clear, because under the ABC test, a worker is presumptively an employee unless the hiring entity can prove all 3 of the following prongs. A, the worker is free from control and direction in performing the work, both under the contract and in reality. And I'm going to say, for the first of many times you'll hear this, the wording of the contract is one important part, but even more important is how in practice does the worker perform their skills. It's what happens in practice will always prevail over the words in a contract. Then, assuming you're free from control, you must show that you're outside the usual business. And this means that the work is performed outside the usual course of the employer's business, or is performed outside all of the employer's places of business. And what does this mean? Essentially, it means that the worker is not intimately related into producing the goods and services that the company sells to the public. So you may have a company that is a garment manufacturer, and if you hire a plumber to come in and work on some of the toilets for the employees in the building, that work is not related to the usual business of the company, and that plumber would properly be classified as an independent contractor. On the other hand, if you hire someone off the street for a week to stand at a production machine to make garments and call that person a contractor, they're intimately integrated into the production of garments that are used to generate funds for the company. So you would fail test B for that assembly line contractor. And then you want to show that the worker is independently established in a trade, occupation, profession, or business. And this again feeds back into part B, in that you have to show that the person not only has their own business, it's a recognized independent business, but it is not directly related to the means of production used by the company. If you don't satisfy A, B, and C, you are an employee. I'm also going to speak very briefly about the Employee Classification Act. Illinois has some very onerous rules for anybody involved in construction, and the primary purpose of this law, which carries heavy consequences, is that anybody working on a construction site should be an employee of someone on the job, because what they don't want is for a contractor to be injured on the job site and not have recourse to workers' compensation and other rights that are associated with employees. Madeline will speak more about this law.
So, Madeline, what could happen if a mistake is made when classifying an employee?
Right. The consequences come from multiple directions simultaneously. So we really have to be aware of how we're classifying our workers and the consequences. So this is the segment everyone should really pay close attention to, because the financial exposure here is not theoretical. Let's walk through it layer by layer. Federal exposure. So let's start with the federal penalties and damages at stake. So the IRS can assess the employer's share of FICA taxes, Social Security, and Medicare for every misclassified worker, going back as far as the statute of limitation allows, typically 3 years, but 6 years if underreporting is substantial. So this is all back employment taxes and penalties. Let's add penalties and interest on top of that. Under IRC section 3509, the employer may also owe a percentage of the employee's share of FICA and income withholding, tax withholding, which in practice can mean an additional 20 to 40% of the back tax assessment. There's also FLSA back wages and liquidated damages. So if a misclassified worker was not paid minimum wage or overtime, the business faces liability for back wages for every unpaid or underpaid hour. Under the Fair Labor Standards Act, the court can, and routinely does, award liquidated damages equal to the back wages, effectively doubling the amount. Add attorney's fees on top of that. In a collective action with dozens or hundreds of workers, the math gets very large very quickly. There's also benefits in insurance exposure. Misclassified workers have retroactive claims for health insurance coverage, 401k or retirement plan contributions, workers' compensation benefits, and unemployment insurance premiums. So, and if your company is an ERISA governed, has an ERISA governed benefit plan, there is a risk that misclassified workers could be deemed plan participants, which opens a whole separate line of liability. The IRS penalty for failure to correct information also returns. So IRC section 6721, failure to file a correct form 1099, when you should have filed a form W-2. This carries penalties of up to $310 per return, with a maximum per employer cap that adjusts annually. So for intentional disregard, there is no cap. Now let's get into some Illinois specific exposure. What penalties apply under Illinois law? Under the Illinois Wage Payment and Collection Act, unpaid wages owed to misclassified employees carry a statutory penalty of 2% of the underpayment per month, which compounds very quickly. Workers can also recover attorneys' fees and costs, making these claims very attractive for plaintiffs' counsels. Under the Employee Classification Act, and this, as Andy was stating, it applies to the construction industry, the penalties are significant and escalating. First violation fines of up to $1,000 per misclassified worker. Repeat violations within 5 years jump to $2,500 per misclassified worker. And then if it's a willful violation or obstruction of an investigation, that triggers double the statutory penalties. And critically, the violation continues. Each day the violation continues constitutes a separate and distinct violation. So that means a single misclassified worker over the course of a year is not one violation, it's 365. A first willful violation is a Class C misdemeanor. A second willful violation within 5 years is a Class 4 felony, carrying potential imprisonment of 1 to 3 years. So let's repeat that last point. A second willful violation within 5 years can be charged as a penalty with potential prison time of 1 to 3 years. This is a serious consequence that goes well beyond civil fines. The Illinois Department of Labor can also issue stop work orders against contractors found in violation of the Employee Classification Act, shutting down job sites until compliance is achieved. So for a construction company, a stop work order could mean tens of thousands of dollars in project delays per day. Debarment, violators can be debarred from actually building on or performing state-funded construction contracts, which for many contractors represents a significant portion of the revenue. So then finally, let's discuss the exposure that doesn't require any government agency. This is the area I want to spend a little extra moment on because this is where the largest dollar exposure typically lives, and it operates entirely outside of any government audit or enforcement action. So class and collective actions, a single misclassified worker who consults a plaintiff's employment attorney can trigger a collective action under the Fair Labor Standards Act or a class action under Illinois law. Once the case is certified, every similarly situated worker becomes a potential class member. We have seen cases where a company that misclassified 50 workers faced a 7-figure settlement demand before ever seeing the inside of a courtroom. Quitam, so under certain federal and state programs, workers can file actions on behalf of the government and share in any recovery. These create a financial incentive for workers to come forward. Tort and contract claims. Misclassified workers can bring state law claims for unjust enrichment, breach of implied contract, or fraud. These claims can carry punitive damages in egregious cases. Competitor and union challenges. So in the construction industry in particular, competitors who properly classify the workers and therefore have higher labor costs have standing to file complaints and sometimes, in some cases, to bring unfair competition claims. Unions are also active in this space. There's indemnification, insurance gaps. So many businesses assume their general liability or employment practices liability insurance will cover misclassification claims, but in many cases it does not. This policy may exclude wage and hour claims, or the insurer may deny coverage on the ground that misclassification was intentional. This means the full cost of defense in any judgment or settlement comes directly out of the company's pocket. So the key takeaway here is that misclassification is not just a tax issue. It creates liability across labor law, benefits law, and potentially criminal law. It can come from the IRS, the Department of Labor, the Illinois Department of Labor, the Illinois Department of Employment Security, and private plaintiffs all at the same time.
Wow. Andy, please tell our listeners how they can protect themselves. Madeline went through a list of huge potential fines and prison time. So tell our listeners what they can do.
Well, there is hope. There is a way to fix any problems that you might have. And it starts by having the courage to identify what you have in place and do you have a problem. And this can be done by doing kind of a self-internal audit. Just look at the scope of your usage of independent contractors. And I think preferably talk to your lawyer first and have the lawyer ask you to do this, to put a legal privilege over this as much as might apply. And I think this is especially important. If you look through your payments and if you have more than 10% of your headcount costs, if you will, are to contractors as opposed to W-2 employees, you need to do this yesterday. If you're under 10%, the risk may not be as severe, but you could still have individual issues. Second, if you identify a problem, begin proactive steps to stop the inappropriate activity that's creating risk. Stop telling the contractor to work set hours. Stop giving contractors company email addresses and company badges. And stop exercising excessive control over how the employee does their job. Now, you may find situations where you need to reclassify a particular employee, and you can't put this off. It should be done proactively. Now, there is a timing element to this. If it's possible to do it without creating undue delay at the beginning of a fiscal year or a new calendar year, it can be easier to make the changes seem less like, oh my goodness, we made a mistake in how we treat you, but we've revamped our company. We have new policies. We're going to make you an employee, and now you're eligible for bonuses, etc., or any other reasons. That is a smoother way for some people to accept changes in their status. You can also look at your current agreements, because you may have in practice people who are doing the right things, but your agreements are toxic. So make sure that the legal integrity of your contracts aligns with how a true independent contractor should be working. I think it's also important to build a documentation file for every contractor. And this should include a copy of the signed agreement, proof of the contractor's business entity, and boy, is it important and good to have your contractor do business through a formal legal entity, such as an LLC. You want certificates of insurance where applicable, evidence that the contractor works not just for your company, but for other clients, and that the contractor is paid via invoices and not via some shadow payroll type arrangement. So this file can be very helpful. Also extremely important to train your managers. And this kind of aligns with another important point. Make sure that the buck stops with one or two people who communicate to each other on permission to use independent contractors. Madeline and I have seen a lot of businesses where there is too much autonomy. Employees in one division may use a completely different standard and have lots of misclassified people, while employees next door in a different business unit follow the rules. Anytime somebody wants to hire a contractor, it should be approved by a central figure of authority or a backup if that person is not available, and they need to compare notes. And managers should also be trained on how to treat contractors as contractors and not inadvertently begin to treat them as employees. And if you do have some severe problems, there are some complicated federal voluntary options under the IRS that allow you to have a chance to have reduced tax penalties. Frankly, that option may not be as viable in a state like Illinois, where this does not begin to address and resolve potential state exposures of coming forward to the government and saying, we messed up. Talk with your lawyer before doing that.
We're right at time, but Madeline, if you want to give us a snack size summary of today's presentation, we would love that.
Yeah, for sure. It won't go too much longer. To summarize, independent contractor classification is a multi-layered analysis. There is no single test, and the tests applied by the IRS, the Department of Labor, and the state of Illinois are different from each other. What passes muster under one test may fail under another. The safest approach is to evaluate every contractor relationship against the most stringent test, which in Illinois would be typically the ABC test that Andy was talking about earlier, and to ensure that both your contracts and your day-to-day operations are consistent with genuine independent contractor status. Whether it be looking for help in classifying a worker or preparing independent contractor agreements for it's really important for employers to obtain guidance from employment counsel with regard to these changes. A word to the wise, be proactive. Don't wait until liability is at your doorstep to act. Kelleher Holland is well positioned to assist you navigating these rules and requirements. And thank you very much for your time today.
Thanks, everyone. Thank you, Madeline and Andy, for your presentation today. If you have any questions, please reach out to our speakers. I have their contact information up on the screen for you, and we will see you next time.